Good morning and welcome to the Baker Botts webinar, the October Surprise, DOJ FTC Guidance for Human Resources Professionals. This is Tom Fina. I'm a partner in the Washington, D.C. office of Baker Botts.
And this is Tom Dillacrath. I'm also a partner in the Washington, D.C. office of Baker Botts, and good morning.
Good morning. Thanks for joining our program. As you all know, Hillary Clinton got her own October surprise from the FBI a couple of days ago. I suspect the Department of Justice's October surprise here in the long run is going to have more impact than the FBI's October surprise, but we'll see. But that's my prediction anyway. One logistical item: for any questions, please send them to andrew.scott, and that's with 2 T's, at bakerbotts.com, and we'll address your questions at the end of the presentation. Okay. In the next 30 minutes, we're going to provide you with an overview of the agency's guidance or policy statement. Secondly, we're going to explain why this guidance is so significant to you and to corporate America. And then number 3, we're going to give you some general guidelines and advice about how to deal with the guidance that the agencies have put out. Last Friday, the Department of Justice and the Federal Trade Commission jointly released what they called their Antitrust Guidance for Human Resource Professionals. While the title is dry and innocuous, don't be fooled. This is a very significant development, and it signals a major change in policy. It's a move from civil to criminal enforcement on naked employee, no poaching agreements, and wage agreements. And the key statement in the guidance is, quote, going forward, DOJ intends to proceed criminally against naked wage fixing or no poaching agreements. Well, what does naked mean? Naked means here in this context without more. It means that the agreements are not an ancillary restraint to an otherwise legal agreement. Why do I say that this guidance is so significant? I think there are 4 primary reasons why it's so significant. First of all, it's a move from civil to criminal enforcement. Civil enforcement is basically a consent order. It basically says, sin no more. Criminal enforcement means fines and potentially jail time for executives. Number 2, DOJ routinely seeks jail time for executives involved in criminal antitrust violations. The Department's position is that while fines are a component of criminal enforcement, what really works in terms of criminal enforcement is jail time. Number 3, these practices are much more common than you might think, and we're going to address that in a little bit more detail later in the presentation. And number 4, the agencies put out this specific guidance. It's not terribly common for them to put out guidance like that, and it shows that the agencies obviously have some real concerns about it. The guidance creates criminal antitrust risk for companies today in a wholly new area, in these no poaching agreements and wage fixing agreements. In terms of the kind of liability that's involved, there are potential corporate fines of up to $100 million plus, individual fines of $1 million plus, jail terms of up to 10 years for individuals, and then there's always, of course, the threat of private treble damage suits brought by affected employees. The guidance also cautions against sharing sensitive information with competing employers, either directly or through third-party entities, and we'll discuss that in a little bit more detail as we move along here. So what's the problem? What's the guidance focus on? There are basically 2 types of agreements that are specifically identified in the guidance. The first are so-called no poaching agreements. And they basically mean no employee poaching agreements. It means agreeing with another company not to hire or to solicit another company's employees. And of the two types of agreements discussed in the guidance, these are the more common of the two. The second type of agreement are so-called wage-fixing agreements. These are any agreement where you're agreeing with another company about employee salary or wages, or to any other term compensation. It could be a job classification, it could be salary or wage ranges for job classifications, or it could be benefits. So those are the two types of agreements that are specifically identified in the guidance that we're going to be focused on today. The guidance also notes that even if there is no explicit wage fixing between companies, exchanging competitively sensitive information could serve as the basis of an implicit legal agreement. And this is basic Sherman Section 1 law. So what do they mean by competitively sensitive information? Here the government's focus is on salary or wage information, benefits information, job classifications, i.e. agreeing what certain job classifications might be and what the standards might be for different job classifications, wage and salary range and wage and salary ranges for these job classifications. Now, this is not to say that all information exchanges with respect to employee wage and benefit information are illegal. They may be lawful if they're properly designed, if they're properly implemented, and Tom will talk a little bit to that later in the presentation. So why should you worry? How common are these types of agreements? My experience is they're surprisingly common. And particularly no-poach agreements are surprisingly common. Both in antitrust audits that I've done over the last 25 years and in routine antitrust counseling, I have routinely found no-poach agreements among companies, and I found suspect or questionable exchanges of wage, salary, benefit information among companies, typically done through the HR department. You see this at three levels, basically, in my experience. You see it at the C-suite or senior management level, where frustrated by high employee turnover with competitors, the CEOs or senior management enter into no-poach agreements with their competitors. And there have been some very public examples over the last couple of years. The high-tech companies out in Silicon Valley were simply prosecuted by the Department of Justice several years ago. Some of the companies prosecuted include Apple, Google, Intel, Intuit, eBay and Intuit, and several others. They were civilly prosecuted, entered into consent decrees, which basically said sin no more. The second level you see it at is at the HR department level. And here you see two things. One is you see suspect or questionable information exchanges with respect to competitively sensitive information about employees. And it may be direct with other companies, or it may be through a trade association or through an industry group. And again, it's typically on wages, salaries, benefits, and or job classifications. You also see HR departments enter into no-poach agreements with other companies. And finally, the third level you see it at is at the level of regional or local managers, acting on their own to deal with employee turnover, typically entering into no-poach agreements to try to protect their employees, try and protect their business. There are obviously industry factors that enhance the risk of these types of agreements. One is relative employee scarcity. Two is scarcity in certain job categories or certain skills. The third is industry or company efforts to manage wage or salary or benefit costs. And that third category has shown up on a number of occasions in the context of hospitals and nurses and the costs of nurses' wages and salaries. So how do these agreements come to the attention of the Department of Justice or to the Federal Trade Commission? Our experience is they typically come to the attention of the government in three primary ways. One is there's simply an employee whistleblower who reports a violation. Secondly, there may be another investigation that the company is involved in, might be a second request investigation, for example, and the agency finds evidence in the second request production of a wage or no poach agreement and opens a secondary investigation. And then the third way that it occurs, although less often I think, is an anonymous tip on the DOJ website. If you go to the Antitrust Division website, there's a place where you can report anonymously on antitrust violations. In terms of the background here, DOJ has been prosecuting these no-poach agreements and these wage agreements for a number of years, going back 20-plus years. The more recent cases have been in the high-tech area and in the healthcare area with nurses. The healthcare area has, or the healthcare cases have involved typically HR administration or societies, associations, where they have set uniform rates for nurses, or they've exchanged information in an effort to keep wages and salaries down for nurses. The FTC has also brought some cases. The FTC has civil enforcement authority only. DOJ has both civil and criminal enforcement. To the extent that the FTC finds something that it thinks should be prosecuted criminally, it can and does refer those cases to the Department of Justice. Last thing I want to say before I turn this over to my partner, Tom Dillacrath, is it's not that unusual for the Department of Justice to move from civil to criminal prosecution. The department will often prosecute various conduct civilly for a number of years. Once they feel like they've got a good understanding of the type of conduct that occurs, and they feel like they have made it clear to the business community that the conduct is illegal and will be prosecuted, they then take the next step and they start to prosecute that conduct criminally. Often, before doing so, they will notify the bar and corporate America that they're going to start prosecuting certain conduct criminally, as they've done here today. Now, Tom, I'm going to turn it over to you.
Thanks, and good morning, everyone, and hopefully this is a pleasant diversion from the other October surprise and can get us away from thinking about that for at least a half hour. Just a reminder, if you do have any substantive questions, please send them to andrew.scott with 2 T's at bakerbots.com, and we'll be glad to address those towards the end of the presentation. So what is the issue? Tom sort of described the background, and given the framework of the guidelines, why are we concerned about this as antitrust lawyers? Well, the antitrust laws really, at least the applicable provisions here, are very brief. Unlike the tax code, where you could fill out the shelves of a small library with all the provisions, the antitrust laws are largely a couple of pieces of paper. Certainly wouldn't take you long to read, and the one that's most applicable here is Section 1 of the Sherman Act, which prohibits any agreements in restraints of trade. Now, taken literally, of course, that's sort of nonsensical. So there's an interpretative gloss put on that. And there's two types of analysis that are done. The first one is the type that requires criminal treatment, and that's so-called hardcore violations or hardcore restrictions, noting that we're talking about naked employees and hardcore restrictions in the same webinar, but that's not quite as glamorous a topic as all that. But the hardcore restrictions include price fixing, bid rigging, and customer allocations, which are all per se violations of the antitrust law, which means they're condemned without any recourse to justification by the party that's engaged in these activities. And the message from the DOJ here is that wage fixing is going to be included, as would naked no-poach agreements, and they'll be treated as criminal and subject to the penalties that Tom discussed. Now, one additional gloss on this is there had been some thinking that, well, if we're engaged in selling soda pop, the competition, the relevant market would be soda pop producers. But that's not the case. It's an employer market. So if you're in the habit of employing IT professionals, you don't all have to necessarily be in the same field to be considered part of that employer market. So, excuse me, there's some nuance to be had there, and something that will require a little bit of thought as one analyzes various no-poach restrictions, which may be justifiable, but thinking about what the employer market would be like is going to be part of the analysis. So we've talked about wage-fixing agreements and the fact that they are, as far as we can tell, uniformly going to be subject to per se treatment. It's hard to imagine any conceivable wage-fixing agreement that would fall outside of that. No-poach agreements are a little bit of a different kettle of fish, and some no-poach agreements may indeed be subject to rule of reason analysis, which means that there would be a weighing by the agencies or the courts of the pro-competitive justifications for a particular no-poach agreement weighed against the anti-competitive effects. And the best way to get this into a rule of reason analysis is by having the restriction or the no-poach agreement be ancillary, and Tom talked about this earlier, to ancillary to a legitimate pro-competitive employer collaboration, so that the hiring rate in question is reasonably necessary to achieve the overarching pro-competitive benefits of the collaboration. Ancillary restraint, what does that mean? It's a little bit of a term of art. See if we can demystify it. It means a restraint that is not imposed for its own sake, but furthers the objective of some other collaboration, and we'll talk about some of those in a moment. But, you know, primarily you think about ancillary restraints in the context of a joint venture. So if our two imaginary soda companies, call them Coke and Pepsi, were engaged in some sort of a joint venture where it made sense for them to share employees in order to produce some new super cola, so there's your pro-competitive justification. That would be a restraint about no poaching might be ancillary as required to effectuate that particular combination, and we'll talk about how that might work in just a moment. So again, wage-fixing agreements, the general guidance is that they're likely to be equated with price-fixing agreements under these guidelines, and documents even suggesting wage-fixing agreements will almost certainly attract scrutiny. Along with the guidelines, you may have noticed that there's a helpful set of red flags that would bring a particular matter to the attention of the regulators, and that would include anything that suggests an agreement with regard to wages, salaries, terms of employment, gym memberships, quotidian things like metro benefits, pretty much anything that would serve as some way to compensate or reward an employee. If there's an agreement between competitors in that employer market to restrict that, that would be found to potentially be violative and certainly would raise the scrutiny of the agencies. And again, just to reinforce what Tom said, the fines are pretty severe, up to $100 million for a corporation, up to $1 million for an individual, and jail terms would not be out of the question. Certainly the agencies have been, the DOJ has been aggressive in the cartel issues in enforcing jail terms and seeking even middle managers to at least spend some time behind bars. So it's very important that everyone be cognizant that that's a real possibility. No poaching agreements, as we talked about, may potentially fall outside per se condemnation if they are ancillary to a legitimate pro-competitive collaboration. Now, that said, that may take you out of the per se realm, but it would still put you into the realm of civil enforcement by either the DOJ or the FTC, whether under Sherman Section 1 or FTC Act Section 5 potentially. The FTC Act, for those of you not familiar with it, is potentially broader than the Sherman Act. It sort of refers to any sort of behavior that might be have an anti-competitive effect, so it conceivably is a bit broader. What types of no poaching agreements are likely to be permissible, and this certainly is not a all-encompassing list, but these are where you would potentially be able to get into rule of reason analysis. First of all, we talked about a legitimate joint venture where two companies enter into an agreement to jointly produce and or market a particular product. Important to remember, the underlying purpose must be legitimate, so the first step is to make sure that the JV or joint marketing arrangement or whatever the arrangement is would survive facially. Secondly, that the agreement is related to the underlying purpose and is as focused as possible. So a broad, vague provision is less likely to survive antitrust scrutiny than something that's really narrowly tailored to effectuate the purpose of the collaboration. And it should always be, needless to say, in writing, no gentleman agreements or winks and a nod. Those are even more likely to raise scrutiny if it's in writing. There's a specific endpoint, a specific set of criteria that is generally going to be more likely to survive antitrust scrutiny. These agreements may be related to M&A activity, so Company A purchases Company B. The parties agree to a non-poaching agreement in the event that the transaction doesn't close, and during the pendency of the transaction, you can see why there would be a logical need to have those. There's a pro-competitive justification simply because you can't move ahead with even beginning the integration process if you think that there's a potential that employees are going to be stolen should the transaction not close, or should it be less than a total acquisition. Related to a legal settlement, such as a theft of trade secrets dispute, that's pretty self-explanatory, and related to the provision of services. So you have consultants, advisors, IT providers. There is an underlying agreement that is perfectly legitimate, and in order to effectuate that, obviously consultants want to have some protection, so there's a narrowly tailored purpose, and that's the sort of agreement that we think is likely to fall within the rule of reason and likely permissible. At this point, a moment I know you've all been waiting for. All attorneys participating via webinar must note this number on their affirmation form to earn the appropriate number of CLE credits, and the winning number is 58582. Again, 58582, so be sure to jot that number down in order to get CLE credits. Now, the second issue we talked about was information sharing, and generally, in the first instance, not prosecuted criminally unless it was, perhaps serving as the basis for some other agreement, but standing in and of itself could serve as the basis for finding a horizontal agreement. And a couple of things to point out. The exchange of current compensation information, and again, that's writ largely, could be wages, could be benefits, could be pretty much anything, would be particularly problematic and likely to call attention by the agencies. You want to generally provide information that is historic and not current or even reasonably current information. A second point is that if you're in an industry where there are a limited number of competitors, then the exchange of CSI related to human resources and in general, moreover, is likely to be more troubling to the agencies than if it's an industry, with a large number of competitors. And finally, the guidelines note that parties to a JV or merger agreement must still exchange caution in exchanging compensation information, and that should be part of your antitrust and integration planning as you move forward with any sort of JV or merger agreement. Again, it's a complex, very much timing-focused issue that requires a lot of forethought to make sure that the right information is being shared at the right time. And again, I direct your attention to the red flags handout that's provided along with the guidelines by the agencies. And they note that red flags here would include the exchange of CSI, or even the receipt of CSI. So if you're receiving but not providing, that could still call attention by the agencies, as well as participation in meetings or even informal gatherings where employment decisions are discussed. So there's a lot to be cautious about in trying to stay clear of any sort of trouble. Common issues that we see in this area, and I think Tom and I have both seen these pretty frequently, would include benefits and salary studies, which are conducted by industry associations and trade groups. That's some of the areas where we've seen this come up in the civil context in the past. Best practices, obviously, again, a complex process, but a few somewhat straightforward principles. The data, to the extent you do this, should always be managed by a neutral third party. It should be historical. It's got to be highly enough aggregated so that it protects the individual sources. And there's got to be enough participants so that the data can't be reasonably disaggregated. So 2 or 3 participants, it doesn't necessarily take a rocket scientist or an economist to disaggregate and figure out, once you back your own numbers out, how things look for your competitors. So a lot of caution should be taken there. There must be a pro-competitive purpose articulated as the underlying goal. That's pretty much a general proposition any time that we're looking at these sort of issues. And again, it frequently arises, as we talked about, during the integration process, and often best to let a third-party consultant handle these issues, at least during the initial phases of any integration. So something to think about for those of you who are active in the M&A world is how to best manage that. So just a few final thoughts as we get to the end of the half hour, and then we'll take any questions to the extent we have any, and I'll just close with a few thoughts. The agencies, as Tom Fina said, very rarely come out with these guidelines, and this means we should take these very seriously. There's no new law passed here or no new principles articulated beyond the fact that there will be a lot of attention on these types of agreements, whether it be wage fixing or no poaching, and that they will now be subject to criminal enforcement, which is a statement that the agencies have not made before. And when you think about this coming in the wake of these high-tech cases that we discussed earlier, and there's a couple of other healthcare cases that are out there pending in the civil world, certainly something that we should all be aware of, and that hopefully your employees will be seeking your guidance on before entering. No poaching agreements that don't fall within criminal enforcement will be closely scrutinized under the rule of reason and need to be thought out carefully so that we think about whether there is a pro-competitive purpose associated with them. The existence of a JV or a merger agreement is not sufficient to insulate such agreements from investigation, and information sharing will continue to be a high enforcement priority. So before we close, let me just check to see if we've received any questions.
And Tom, we do have some questions. We've received 4 questions here. Let us go through them. We'll read the question without attribution to who sent it, and we'll briefly answer. I'll go first here with the first question. The first question is, does the anti-poaching concern apply in the M&A context where these types of arrangements are common, i.e. a target wants to protect its employees? The answer is yes and no. Certainly in an M&A context where parties are engaged in negotiations with respect to a transaction or have negotiated a transaction, anti-poaching agreements are common in an agreement. And there, as long as they are narrowly drafted and they're narrowly targeted to protect the employees during the pendency of the negotiation or during the pendency of the clearance of the transaction, the anti-poaching agreement would be analyzed under the rule of reason and would likely be found to be legal and would not create significant antitrust concerns. Tom, do you want to take the second question?
I'll take the second one. And the question is, I'd mentioned earlier that wage fixing agreements would almost always be per se violations. What about an agreement to maintain wage level of employees for a period of time following a merger or divestiture? And I think that is a pretty fact-specific inquiry, but were it to be narrowly tailored enough and have a pro-competitive justification, I've seen this come up where, for example, there are things built into existing employer contracts that call for that. So I could imagine scenarios where that would be one of the exceptions, where there would be a wage fixing agreement outside of the traditional context and in connection with some other transaction that could conceivably fall within the rule of reason analysis. But that would need to be looked at very closely on a case-by-case basis. I don't think you could say as a general rule that would be okay, but there would be situations where that might be an acceptable way to proceed. Tom?
All right. Let me read our third question here. The tone of the guidance has been employers and even competitors. Do you think that there are implications in common agreements in which a company includes non-solicitation provisions and non-compete agreements with key executives? I suppose those executives could later create a competitive enterprise, which makes the matter potentially more challenging. The non-solicitation provisions are common in executive agreements. I think the answer here is probably not. I think the answer is probably not. Executives routinely enter into non-compete agreements with companies. The legality of those non-compete agreements, tends to vary state by state. Some states are more generous than are others. But I don't think that the addition of a non-solicitation agreement in the context of a non-compete agreement is what the Antitrust Division or the Federal Trade Commission is specifically looking to here. I think instead they are looking at existing companies that are agreeing not to solicit employees from one another. So I think the answer here on the third question is probably no. Tom?
Sure. And the last question I have right now is whether it is possible to enforce a non-solicitation agreement post-employment that a former employee signed during employment, and the new employer may or may not be a competitor. And I think the answer here, without weighing in on the specific facts too heavily, because I think we need more to really analyze it, is that this is along the lines of the last question Tom Fina answered, which is that this isn't really the type of agreement that these are looking to catch. This is really looking to catch agreements between two competitors in the employer market, mind you, but between two companies who are competing for the same pool of employees. And that's really what is being sought here, not so much what you might consider vertical agreements between employee and employer. I think while there are still antitrust questions that may arise in connection with such agreements, those are really not what the guidelines are directly seeking to look at. So I don't think we have any other questions. So we thank everyone for your time today. Hope you found this interesting. Please feel free to reach out to either Tom Fina or myself should you have any additional questions. And I hope everyone has a very pleasant Tuesday.